and Dowling. Yes, I appear for the plaintiffs in that matter, Your Honour. Thank you. Mr. Dowling, can you hear me?
Yes, Your Honour. Who was that first person?
So the first person who spoke was Mr. Smark of Senior Counsel, who appears for Seven Network.
Yep.
Yes, Mr. Smark. Your Honour, the plaintiffs have provided to Your Honour's associate a notice of motion and supporting affidavit which concern the particulars to the statement of charge in relation to the charges brought by Mr. Dowling against various persons, the hearing of those charges being listed before Your Honour on the 3rd of December.
Yes.
The statement of charge appears as an annexure to Mr. Dowling's notice of motion, which was filed on the 2nd of July 2019. Does Your Honour
I have that, thank you. I'm working off the court book that was prepared for the earlier occasion.
Yes.
It's page 12, I think. Have I, just as a matter of formality, I know we were dealing with this today, have I formally made an order granting you leave to file?
No, and we haven't paid the money that...
Yes, well, it is your supposed to give the undertaking to pay the filing fee?
Yes, indeed.
Yes.
Your Honour, just a couple things. One, I was going to make another application for you to stand down from hearing this matter. Two, I'm in Queensland now. This matter should be transferred to Queensland. Three, it probably should have been, well, not probably, it should have been struck out for want of prosecution a long time ago. It's been dragging on for years. But the key thing is an application for you to stand down, given I have further evidence of perceived bias and actual bias. Let's not kid ourselves. We all know that Chief Justice Tom Bathurst has instructed court staff to stitch me up. That shows up in a police statement by Chris Dave and a subsequent frivolous and vexatious police charge and police raid on my unit. And there's further evidence. So, you know, for this court to even try and perceive there's some sort of impartiality in hearing my matters is a joke and a scandal. But specifically in relation to you, Your Honour, you know, there's a number of issues there that show further perceived bias. The fact that we're even hearing this today, for starters, you lying and concealing your relationship with Dr. Nicky McWilliam and Bruce McWilliam, and a number of other issues. And I'd like to make that application to start off.
Did you say lying and concealing?
Yeah, your relationship with Dr. Nicky McWilliam and her husband, Sevens Bruce McWilliam.
We dealt with that on the last occasion, Mr. Dowling.
No, well, there's other issues. We haven't dealt with, and you haven't dealt with in your judgment. Now, it's well known that Chief Justice Tom Bathurst ordered staff to stitch me up for jail time because I sent an email into the court naming him as a known pedophile and numerous other judges as either known pedophiles and suspected pedophiles back in September 2016. He's never denied the allegation. He's had opportunity after opportunity to deny it, and so have the other judges. So as it currently stands, the court's got no option but to take it as being true and correct that they are pedophiles. Now,
but why should that prevent me from hearing the matter? As I understand it, I have not been named in those emails, and so it's got nothing to do with me.
He's ordered the senior court staff and Chris Day's witness statement to stitch me up. Now, the average person would say, look, if he's ordered those staff, he's obviously ordered everyone else to stitch me up. Now, you have deliberately concealed. You say you've got a relationship with Dr. Nicky McWilliam and Bruce McWilliam, but you could have raised that earlier. Not only that evidence is before the court that Chief Justice Tom Bathurst is a pedophile, known pedophile, suspected pedophile, bribe takers, all those judges, because they subpoenaed that evidence from the New South Wales Police. The applicants did in this matter, 7 West Media and 7 Network. They subpoenaed that from the police. So that evidence is before this court now. In this specific matter, is Chief Justice Tom Bathurst a known pedophile? That's an issue that they put before the court, not me, by their subpoena, which uses the courts allowed it. Another issue is, in my research, I found out that Your Honour is a Knight Commander of the Order of St. Gregory the Great in the Catholic Church. Now, it's well known the Catholic Church have been running the biggest pedophile ring globally for decades. Now, Your Honour is obviously a senior member of the Catholic Church, and here you are hearing a matter where there's evidence before the court, which the applicants put before the court via their subpoena, the New South Wales Police, that Chief Justice Tom Bathurst is a known pedophile, that Justice Clifton Hoban is a known pedophile, and others, Justice Ian Harrison.
Darling, I can assure you, without wishing to engage in the particulars of what you have just said, beyond confirming, yes, I am a Knight Commander of the Order of St. Gregory the Great, conferred by the Roman Pontiff, but I have not discussed you, your matter, or anything else with Chief Justice Bathurst, and I should place on the record that his Chief Justice is certainly not presumed to speak to me about the matter, let alone give me any directions.
It's blatantly obvious you have taken directions, John. It's blatantly obvious you have taken directions.
Well, Mr. Dowling, I think the orderly way to proceed, as I understand it, you want to make a further application for me to disqualify myself, and you wish to make an application for these proceedings to be transferred to Queensland.
Yes, Your Honour.
Those matters cannot be dealt with, as it were, on the run in a directions hearing of this kind. And all I'm doing is dealing with a short procedural notice of motion. I propose to deal with it. If you want to make applications for me to disqualify myself, and indeed for the proceedings to be transferred to Queensland, then that can be done when the matter is fixed for hearing before me, and we'll have to deal first with your transfer applications and your disqualification.
Well, Your Honour, when you set this hearing down for the applicants today, your associate took the private communication from them. She was well aware I was making those applications, and she could have made sure they were set down for today. So that's actual bias, not perceived bias, that's actual bias. So here you are saying, oh, well, they approach me and I can set their notice down, but I can't set yours down, Mr. Dowling. Well, that's not perceived bias, it's actual bias.
Mr. Dowling, I only had a limited amount of time today because I was in the course of another hearing. In fact, I was meant to be duty judge. I cleared half an hour for dealing with this application. I will entertain whatever applications you want when the matter is back before me in December, and we'll make some timetable directions to enable that to be done on a proper basis. I will, of course, hear Mr. Smark about that, but prima facie, it seems to me, if you want to make those applications, I'll have to deal with them before I embark on hearing the contempt matter. The other matter, frankly, Mr. Dowling, is I assume that you were going to come down to Sydney for the December hearings.
Of course I'm not, I can't afford to. Of course I'm not, Your Honour. And that's another thing, you're going to deny me natural justice. If you transfer it to Queensland, I can show up to court because I'm only a couple of hours from Brisbane. So you're going to deny me natural justice? Of course I'm not. I moved up here for a whole heap of reasons, and cost is one of them.
I beg your pardon, what was the last thing you said?
I moved up here for a number of reasons, and cost is one of them. I can't afford.
Well, it's a matter for you whether you're here for those hearing dates. There may be a question as to the appropriateness of your not being here. I'll have to hear Mr. Smark about that. But it would be much easier, both for you to advocate your cause and for the court to deal with any application, for you to be here.
Well, you're dealing with my application now over the phone, or their application over the phone. Answer me this.
It's a very simple and straightforward application. The applications that you have foreshadowed are neither simple nor straightforward.
Of course they're straightforward. Answer me this. Have you and Dr. Nikki McWilliam ever had a sexual relationship? Answer me that. Have you and Dr. Nikki McWilliam ever had a sexual relationship?
Mr. Dowling, I'm in two minds about whether I should answer that question. Firstly, because it seems to me to dignify an entirely improper question of a judicial officer. However, in the interests of candour, I can answer that question absolutely in the negative.
Well, she hasn't refuted it. She's admitting it.
My relationship with Dr. McWilliam, as you choose to call it, was disclosed on the last occasion and is set out in my reasons.
In relation to your position as Knight Commander of the Order of St. Gregory the Great, would you like to apologise to all the survivors and victims of the pedophile priests? Well, it's your role as Knight Commander of the Order of St. Gregory the Great, isn't it?
Now,
You're a senior member of the Catholic Church, which has been running the biggest pedophile ring in the world for decades. And here you are, presiding over a matter where there's evidence before the court that Chief Justice Tom Bathurst is a known pedophile, and he's had opportunity after opportunity to refute it, but he refuses to do so. What he's done, he's ordered senior court staff to stitch me up for jail.
well, Mr. Dowling,
And
I don't know anything about that.
Of course you do. The evidence is before the court.
Your matter was assigned to me in the ordinary course of the
Ah,
internal processes of the court. I had no role in the matter being assigned to me. It is here. It is my constitutional duty to adjudicate upon it, unless you can present proper reasons why I should not do so. I dismissed your application on the earlier occasion. If you say there is new material that would justify a further application, I will of course entertain it, but it should be done on proper notice in a way that everyone has a fair opportunity to be heard, and
Well,
that means you.
I'll email it in like the others. They did. They just emailed it in. That's what I'll do.
You can email it in once I've made some directions about it. We are going to have to hear it. What I first propose to do, Mr. Dowling, is deal with the application that is before me, which is the notice of motion that I did give permission to be filed or to be brought before me today. I assume you have received in good time the notice of motion and the affidavit in support?
Yes, I have, Your Honour.
All right. Well, I'm just, as a formality, I'm granting leave to Channel 7, or the two plaintiffs, to file in court the, I don't suppose you've got an original somewhere, Mr. Smart, of this in the affidavit, so that the record is pristine.
Yes.
Don't you think that applicants should be filing evidence to prove Nikki McWilliam has not denied the sexual relationship with Your Honour? She hasn't denied it. So she's basically admitted it. And that's a very serious issue. You're deliberately concealing your relationship with her and Bruce McWilliam. You could have raised that a long time ago. You said we've been before you before. Why didn't you raise it a long time ago?
As I indicated in my reasons, it was only on that last occasion that Dr. McWilliam had anything to do with the matter. Now, let's have a look. I've got the motion here, the original, which I grant leave to Channel 7, or the plaintiffs rather, to file in court a notice of motion dated 15 November 2019, and I grant leave to the plaintiffs to file in court the affidavit of Richard and Michael Keegan, sworn 15 November 2019. Now, you have both of those documents, do you, Mr. Dowling?
They're somewhere, Your Honour. I haven't read them.
You haven't read them?
No, of course not.
All right, well, that's...
Because you shouldn't even be hearing it. Evidence before the court that Chief Justice Tom Bathurst is a child rapist. He's had opportunity after opportunity to refute it. The police told me they were going to contact everyone on that list, the email I sent, so that means they would have contacted him, and he had an opportunity to refute it. He hasn't, and here you are trying to hear the matter. Of course you've been instructed to stitch me up. You know you have, and you're lying on the bench about it. This matter should be transferred to the Queensland court. And when I was in court last time before you, there was 3 court sheriffs in court harassing me. Now you instructed them to leave. When I went outside, 2 of them were still outside, so they were still out there intimidating me. And you're part of that process, threats and intimidation.
Mr. Dowling, as you have correctly recorded, I instructed them to leave my court.
And they were still outside when I left, and I emailed your associate, and your associate said, oh, you'll pass it on to Chris Dave, who was the person who made the complaint to the police after he was instructed to by Chief Justice Tom Bathurst. So you're saying I should fly down there for the hearing. If I go down there for the hearing, I'm going to be bullied and harassed. I can't get a fair go in the courts down there, and you know it. You've seen it in full flight. And I bet you had a good laugh when you emailed the complaint to Chris Dave, the issues of Chris Dave, because you knew he was going to do nothing. He's the one who made the complaint to the police in relation to me naming Chief Justice Tom Bathurst and the other judges as pedophiles or suspected pedophiles. So,
Mr. Dowling, all I propose to do is to prepare these applications, including the ones you foreshadowed for hearing, but we do have a motion before us today. I will not deal with an application to recuse myself today. I will, however, proceed to deal with the notice of motion.
well, who's representing Kerry Stokes? Who's representing Bruce McWilliam? Who's representing Tim Warner, Richard Keegan, Martin O'Connor, Alexander Latu, and 7 Network and 7 West Media today? because Kieran Smart can't. He's actually a respondent in the matter. And Kieran Smart knows that full well, and so do you. He can't represent the rest of them. And you know it. And Justice Sakar pointed that out in another proceeding when he notified Barrister Sandy Dawson, look, you can't represent them all because you're a respondent in the matter. And you know full well, you know you're pulling a Swifty and you've been caught out red-handed right now. You know Kieran Smart can't represent the rest. This is the third time they've showed up to court with no representation. Only Kieran Smart showed up and he can only represent himself. So you cannot let these proceedings go forward today. You have to hand down summary judgment against the rest of them because they've got no representation. Smart can only represent himself. And Justice Sakar basically, in effect, told Sandy Dawson that exact same thing. And the following week, a couple of weeks later, they showed up with an independent barrister who was independent from the proceedings. So for you to allow this to go forward shows you're on the take. You're taking a bribe, aren't you? You'd have to be, wouldn't you, to allow something so corrupt to go forward?
Mr. Dowling, I'm just going to ask Mr. Smart a question. For whom do you appear today, please, Mr. Smart?
The plaintiffs.
Yes, well, Mr. Smart is here for the plaintiffs.
Well, he can't. He's a respondent in the matter. He's personally a respondent. I've charged him with contempt. And Justice Sakar told Sandy Dawson that exact same thing when contempt proceedings were before him in similar circumstances, that he can't represent the rest. And here you are, it's the third time.
He's not here purporting to represent any of the others. He's told me he's here for the two plaintiffs.
Which two plaintiffs?
Whatever else he may do, and for whomever else he chooses to appear or not appear are matters for him.
Who's the two plaintiffs? Did you say the two plaintiffs?
The first and second plaintiffs, which are 7 Network Operations Limited and 7 West Media Limited.
Well, others don't have representation. It's the third time they haven't had representation. You have to hand down summary judgment against them.
Well, they are not applicants on the motion, as I understand it.
Well, it's the third time that this matter's been listed in court and they haven't had representation. You have to hand down summary judgment. You've got no choice.
Well, there's no application for summary judgment.
Well, I'm making it now, Jon, and you know they haven't been represented.
Well, that may be an application that you may wish. I will also list for hearing when that matter is before me.
You can hand it down now. Look, stop the game. We all know, everyone knows, it's all over my website that I've named Chief Justice Tom Bathurst as a known pedophile, Justice Clifton Hoban as a known pedophile, Justice Ian Harrison, Justice Lucy McCallum, etc. And they all had the opportunity to complain to the police. They refused to. They all had an opportunity to deny the allegations. They refused to. And here you are trying to stitch me up again.
Well, let's deal with the motion. Mr. Smart, what do you want to say about the motion?
The statement of charge, which appears using the page numbering from that court book at page 12, and for Mr. Dowling's benefit, is the first page of Annexure A to his notice of motion filed on the 2nd of July 2019. Sets out under the heading charge about partway through or halfway down the page the matters which are said to form the basis of the allegation of contempt against the various persons there named. On the 18th of October 2000, I should read the affidavit of Richard Michael Keegan, dated the 15th of November 2019.
Yes.
And I may take that as read, Your Honour.
Yes.
The letter of the 18th of October 2019, to which I now turn, is page 5 of that affidavit, being the second page of Annexure A.
Yes.
And, Your Honour, substantially by reference to the statement of charge itself, the letter seeks particulars of the charge. Your Honour will see that the most important part of the charge appears at paragraph 3, 4, and then a second numbered 4, seems to be a match with the numbering. And it's the contention on the part of the plaintiffs in the proceedings that the charge does not properly identify the nature of the conduct of the various persons, which is said to constitute the contempt, and therefore it's not known what can be done about the charge because it's not clear what it is. And so the letter sets out some matters which they're a fairly short compass, which one would think if Mr. Dowling was in a position to lay a charge, which is a not unserious matter to do, against various persons, he ought to know what those matters are. So we would seek those particulars. Yes. I should perhaps add one thing, Your Honour, and this is as a matter of fairness to Mr. Dowling. Mr. Dowling may not be aware that in order to prove a matter of charge, ordinarily evidence is received by affidavit under the rules. As far as the plaintiffs are aware, the only affidavit that's been filed in support of the contempt charges laid by Mr. Dowling was the affidavit that was filed at the same time as the notice of motion. That's to say Mr. Dowling's affidavit of the 2nd of July 2019.
Yes.
But it seems to contain, although it contains many other things, nothing that materially bears upon the substance of those allegations, whatever precisely they may be.
Yes.
It's not ordinarily, or perhaps ever, permissible to flesh out charge of contempt by reference to affidavit materials or arguments or submissions. It has to be a thing that on its face bears the allegations for consideration. But in any event, even if it were permissible, it can't be inferred or deduced by reference to Mr. Dowling's affidavit. Mr. Dowling hasn't given any indication that he's going to seek to produce evidence in some other way. It would appear that the material references are to two types of things, at least in the main. One is the contents of an affidavit, which is referred to in first numbered paragraph 4.
Yes.
We're not trying to be difficult. We can work out what affidavit that was. It was evidently an affidavit of Mr. Martu of the 28th of May 2019. And the second thing is, it's some things that were said in the course of a hearing on that day. And again, we're not trying to be difficult. It's evident to us, that's to say to the plaintiff's camp, that the hearing in question, the court is Registrar Walton, because that was the only manifestation of the court. That's where the matter was in court on that day. And we have the transcript of that day. But that doesn't place the plaintiffs in any better position to know what it said was false in that affidavit or in what was said.
Yes.
Or why.
No, I understand, Mr. Smoke. I don't need to hear any further. Mr. Dowling, have you read the letter from Mr. Keegan addressed to you of the 18th of October 2019 requesting the particulars?
No.
Well, it's attached to the affidavit that you've told me you haven't read.
Yep.
And why should you not give proper particulars of the very serious allegations that you have made in the statement of charge?
Well, it's quite simple, Your Honour. This matter has been going on since early 2017. I can't remember the exact month. I think it might have been April or May, but I think the contempt proceedings is June, July 2017 they instituted against me. They can confirm those dates. I can't remember off the top of my head, but I think I'm fairly close. Now, this notice of motion for contempt I filed has been before the court since June or July this year. They've had opportunity after opportunity to file for further and better particulars. They haven't. It's just another time waster. They know exactly what they've done. Two,
Darling, it's not for them. Sorry to interrupt you there, but just picking up that point, it's not for them to know what they have exactly done, or what they've done. They need to know what it is you say they have done, because you will need to prove that they have done it.
Because, Your Honour, as I said, they've had months and months. This is a slap lawsuit. They've been dragging everything out. They've had since June, July this year to email or ask me for further and better particulars. Now, when I emailed them for further and better particulars, they answered one or two things and said, get stuff to the rest. I had to go spend money and file a notice of motion for interrogatories and discovery to try and get further and better particulars, but you rejected it. And here they are a week or so before the hearing's meant to go forward, and here they are demanding further and better particulars. This is a game they're playing. That's what, if I'm not entitled to further and better particulars and I have to file a notice of motion, you reject a lot, which is consistent pattern with all other judges. I've never been allowed interrogatories and discovery, and that shows bias there. That shows Chief Justice Tom Bathurst has sent word down the line to everyone to stitch me up, and I've never allowed it. Not allowed fee waivers, even though I've got a healthcare card. The police have raided my place twice. Oh, well, they raided it once, and they come and harassed me earlier this year on the instructions of Chief Justice Tom Bathurst again. And so if you're knocking me back for further and better particulars, which you did in that previous judgment, which was interrogatories and discovery I had to file because they were refusing to answer my further and better particulars I was asking for. And here you are a week before the hearing, and they say, or a week and a half before the hearing, they say, oh, we want further and better particulars. Well, no, get lost. They know exactly what they're doing, and they haven't even got representation anyhow. That's a scandal. This hearing shouldn't be going ahead.
Yes, all right. Well, you've raised one point that I should ask Mr. Smark about. Why has it taken as long as it has to ask for these particulars?
Your Honour, the time it was first raised was the 18th of October 2019. That was 6 weeks before the hearing of the motion. It would have been better to have asked it before. On the other hand, two things. One, as I said, given the nature of the charges, presumably the substance of them must have been in Mr. Dowling's mind. He must have had in mind at the time he laid the charges what they were. Second, they seem to be very simple matters to answer on their face. That is, presumably there's a point in the transcript where what I said is said to be false and why. There must be a point in the affidavit where what Mr. Lartu said was false and why. And to the extent that the words lawyers or applicants goes beyond that, and it's not clear which persons are embraced in that. If it's said of the Channel 7 companies that they've engaged in some particular conduct, Mr. Dowling must have that in mind, must be able to point to some conduct, whether it's direct or derivative through its agents.
Yes.
So it would have been better, I accept, to have asked it earlier, but 6 weeks for such simple questions, in my respect, ought not to be an impediment to the particulars being given.
Yes. Well, Mr. Dowling, it seems to me, with respect that that is right, I have read Mr. Keegan's letter of the 18th of October. The questions that he asks are focused on very specific matters in the statement of charge, which you should, if you know what case it is that you wish to make, when this matter is heard before me week after next, you should be able to give a pretty simple answer to.
Well, you're going to go. Oh.
Go on, Mr. Dowling.
Yeah, no. It's very simple. It's not perceived bias, it's actual bias. You're sitting back saying that in relation. I asked some very simple questions of them too, and they refused to answer, and I had to go file a notice motion for interrogatory and discovery, and you refused that. I asked very simple questions like, who were the owner of that website, was it 7 versus Amber or whatever? And they couldn't even respond and answer that. They're very simple questions, and you're saying on their behalf, oh, the only very simple questions they asked Mr. Dowling, well, mine were too. And they refused to answer them.
Well, Mr. Dowling,
and here we are a week and a half before the hearing, and they're demanding, oh, we need further and better particulars. And here you are siding with them after private communication you had with them.
Reasons for how I dealt with your application. I take it that you have not sought to appeal from my judgment.
But I'm not. That's another problem, Your Honour. That's why you shouldn't be hearing it, because I'm not allowed fee waiver, even I have a healthcare card, and that's the whole grubby stitch up by Chief Justice Tom Bathurst. If I apply for fee waiver, they refuse it. Well, they might, and if I appeal or have it reviewed, it goes to Chris Dave, and he's the one who made the complaint after he was instructed by Chief Justice Tom Burthurst to the police about me sending that email naming 18 people as known pedophiles and suspected pedophiles, and they haven't refuted it. So,
Mr. Darling,
so you sit back and say, "Oh, you haven't appealed." Well, I can't afford to appeal, can I? I'm being denied natural justice.
In my view, Mr. Darling, the questions which are asked in the letter of 18 October are entirely relevant and should be something that you can answer really quite simply if you know what case it is you wish to make when the application for contempt is heard. So I am going to order you to provide those particulars, and we can work out how it's going to take you to do that in the context of the hearing, because I've also got to think about some directions for the applications that you've foreshadowed, if you want to make them, and also generally to prepare the matters for hearing. Because I don't think, Mr. Smark, there is a usual order for hearing been made.
Yes.
Or did I make it?
I think, Your Honour, did I have in my mind, Your Honour, that on next Wednesday we've been directed to comply with the usual order for hearing, supplemented, I think,
Yes, by my little additional orders, yes. Yes, I did.
two additional orders. One, I think, related to an extended statement of facts. I may have that wrong.
Statement of facts and an extra copy of the court book.
That's so.
Now, are you going to do that for both motions? Mr. Dowling's motion as well as a litigant in person, in terms of preparing whatever materials there are that you know about? Because I made an order in relation to both motions. So the question is who's going to prepare whatever Mr. Dowling's...
We don't wish to take advantage of any lack of resources Mr. Dowling has, of course. If Mr. Dowling were to let us know what he wishes to be included in the court book, then we will include it. If we think it's irrelevant, so be it. It can go in and there could be some argument about that, but it shouldn't be for us to edit the...
No, I'm just the practical question of the preparation of the
the
court
answer
book.
is yes.
Well, Mr. Dowling, yeah, you can have the diary, please. Dealing firstly with your motion, because that's what this application today relates to. Do you know what evidence you wish to rely upon?
No, I haven't looked at it for a while, Your Honour. I've moved up here and that's been my focus the last few weeks.
Well, just having a look. Did we list Mr. Dowling's motion for the Tuesday? I think.
No. Yes. I'm sorry. Yes. Yes, that's right.
Yeah,
And
so,
Your Honour, I'm sorry to interrupt, but just while Your Honour's mind is turned to it, it's going to be procedurally convenient, if we could, to keep the matters listed on different days.
I understand that, but I'm now going to have to deal with potentially two other applications.
Yes.
On day one.
They have to be heard first, Your Honour. I accept that.
That may have the consequence that first motion will go over, there'll be a spillover into the second day. But they will be heard procedurally separately.
Yes.
Yes, all right. Well, Mr. Dowling, when can you... I'll withdraw that. All the court has at the moment in relation to your notice of motion, which is presently fixed for hearing before me on the 3rd of December, is the motion itself, and it was filed with an affidavit of yours to which Mr. Smark has made reference of the 2nd of July. So on its face, as far as the court is concerned, that appears to be the evidence that you will be relying on. There may be other material that you wish to rely upon. So the Channel 7 have agreed to take the administrative burden of preparing a court book. Are you able, by say next Tuesday, to have firstly answered the particulars that are sought in the letter of 18 October, and secondly have provided to or told Channel 7 what additional material it is you wish to rely on in your motion?
I can do that by next Tuesday. One thing, if the application to have the matter transferred and for you to recuse yourself and or an interstate judge be brought in, I was expecting to be heard today. But if you're planning on hearing them the same time as the hearing, which it sounds like it, I'm obviously going to have to apply for legal aid, and I'll have to do that next week. It's too late now. Oh, well, it's not too late, but it takes a while to sort it out and get paperwork ready. So I'm going to have to apply for legal aid next week, and that's obviously, based on my experience, will delay the proceedings until I can get legal aid approved or not, because I'm entitled to a legal defence.
Mr. Dowling, you can take whatever course you want, but at the moment, in the absence of an application for an adjournment, these matters are being heard by me on the 2nd and 3rd of December.
Well,
subject, of course, to dealing with your applications for transfer and for me to recuse myself.
well, I'll apply early next week, then I'll email your associate and other parties once I've applied for legal aid.
And what is it you will be applying for legal aid for? What?
For the contempt proceedings against me.
So you will be applying for legal aid for someone to appear for you in the contempt proceedings against you?
Yep.
Right, well, that's only one aspect of the matter that's going to be heard. What about your contempt action against Channel 7?
Well, I think that can go forward, but my viewpoint is it's fairly simple. They are interrelated, and they should be dealt with together. The other party might have a different viewpoint, but I think they're interrelated.
And what about your applications that you foreshadowed for transfer and for me to recuse myself?
Well, those two, I know, for something like that, I won't get legal aid anyhow. So I'll have to represent myself on those two applications.
Yes. All right. Well.
But I know for the contempt proceedings against me, yes, there's a good chance I can get legal aid.
Well, you've left it a bit late to apply, Mr. Dowling.
Well, it should have been removed, Your Honour. This has been dragging on for years. This matter should have been removed. I emailed them a couple of weeks ago saying let's remove this to the Queensland Supreme Court. There shouldn't be an issue. So saying I'm leaving it till last minute, you've got to be kidding. You are joking, aren't you? The way they've abused the system. This should have been struck out for want of prosecution a long time ago. Say to me.
I should ask Mr. Smark the question. Do you have any instructions as to your client's attitude to the cross-vesting application?
I don't. I can imagine what they would be.
Yes.
I don't actually have those instructions.
Yes. No, I understand, and at the moment, there may even be questions as to whether it's capable of being cross-vested. I haven't looked at that.
Well, the Capilano Honey matter, which is a very similar matter, where they're suing me as well, the associated matter, for want of a better description, is the Simon Mulvaney, Capilano Honey v Simon Mulvaney. That was transferred last year to the Victorian Supreme Court by Justice Lucy McKellum. My situation and the proceedings are very similar, and my matter should be transferred to Queensland as well in that matter, but they're arguing against that as well. When when both the applicants are actually based in Brisbane, it's ridiculous. So there is a legal proceeding, there is a legal precedent to transfer.
Well, that's very helpful to know. Thank you, Mr. Dowling.
Two matters, I should say, I suppose, properly seen as being fairness to Mr. Dowling arising from that. The first is that there may be a distinction between the transfer of proceedings generally and the transfer of contempt matters, because contempt matters might be seen as being particular to the administration of the court in which conduct in question occurred. I'm not putting that as a submission, I just raise it as a possible consideration.
Just quickly, Your Honour, that was a consideration in the Simon Mulvaney matter as well, so if you read that judgment, Justice McKellum deals with it.
Well, that's good to know, Mr. Dowling, but those are the sorts of issues that would certainly be exercising my mind.
The second is that, just so there's no misleading of Mr. Dowling, that by our silence we might be thought in any way to acquiesce in the suggestion that it would be appropriate to adjourn these applications, which are to be heard on the 2nd and 3rd, respectively, of December, by reason of an application for legal aid. Although I don't have instructions, it's just having been raised, I anticipate it would be opposed if there were to be made such an application. I won't say more because the application for adjournment hasn't been made.
Yes, well, you've heard that, Mr. Dowling.
Yeah, I think they maybe, in relation to the second application, which is mine, they might have grounds. But the first application, no, I'm entitled to legal aid. They flagged they want me jailed for the contempt proceedings. I'm entitled to be represented and apply for it. And I know that process very well because I had to do that in the Prothonary matter. Well, I went to jail last year for 4 months for I was convicted of calling Justice Clifton Hoban a pedophile, which he never refuted too, I might add. But I did 4 months jail, and I know that process well because it was a very long-winded process trying to apply for legal aid. But I'm entitled to have it adjourned until they determine whether I can get legal aid or not. Ultimately, I did get legal aid.
Yes. I'm just formulating some orders here, if you just bear with me, please, Mr. Dowling. Mr. Smark, in relation to channels, the plaintiff's motions for contempt against Mr. Dowling, obviously enough, I'm not going to make any directions against him to put on any evidence or anything like that, but you'll prepare the court book in accordance with my directions insofar as there's material that you'll be putting before me on that matter. Yes, all right. And that'll be provided to Mr. Dowling.
Yes. We'll provide it. We have an email address and I think a physical address.
Yes, it may be helpful to provide it electronically.
Yes. Unless Mr. Dowling says otherwise, we would probably provide it electronically, and making sure that it's can be transmitted electronically. We might have to break it up into a few bundles.
Yes. Mr. Dowling, is that the best way for them to send material to you in relation to the motion against you, that they send it to you to your email address?
Well, they can do that. When's it going to be finished by or finalised by?
I think the direction, I think it was 3 business days.
Yeah, I think the Wednesday.
Yes, you'll get it by
If you make it Tuesday, they can mail it to me as well. So I can have hard copies in front of me.
Well, they perhaps might express post it as well to the post office box.
We'll do that. It'll be the Wednesday.
Yes. Well, you'll get it by email and they'll express post it as well.
Yep, so I'll at least have one copy, hopefully both.
Then I need to make some directions in relation to your applications. I take it, Mr. Dowling, just for clarity's sake, that you wish for me to deal with any recusal application as the first item on the agenda, even before we get to your motion for transfer of proceedings.
Yes, Your Honour.
Very well. What I have in mind, Mr. Dowling, is to direct that any motions by you for me to recuse myself and to transfer the proceedings, together with any affidavit evidence in support, be filed by you and served on or before next Thursday, the 28th of November. And I propose to direct that can be done by email to my associates and email to Channel 7 solicitors. And those motions will be returnable before me at 11 a.m. on the 2nd of December.
Yep, no, that's fine.
And I will direct any evidence in response to those motions from the respondents, perhaps just to be filed and served in the same way by close of business on Friday next week. Thank you. Very well. The directions of the court are as follows, and Mr. Dowling will email these to you when we've entered this afternoon.
Yep.
1. On or before Tuesday, 26 November 2019, Mr. Dowling is to A. Provide answers to the letter of 18 October 2019 to him from Addison's, semicolon, and B, notify and where necessary provide copies to the Channel 7 parties of the material to be included in the court book in connection with Mr. Dowling's motion, in connection with the hearing of Mr. Dowling's motion filed 2 July 2019. 2. Any notice of motion by notices of motion by Mr. Dowling for the recusal of Kunstje and the transfer of these proceedings, together with any affidavit in support, be filed by email to the associates to Kunstje and served by email on the respondents on or before 28 November 2019, with such motions to be returnable on 2 December 2019 at 11 a.m. before Kunstje. 3. Any evidence in response to the material referred to in the preceding order is to be filed and served by the Channel 7 parties by email to the associate to Kunstje and to Mr. Dowling on or before 29 November 2019. Now, is there anything else, Mr. Spark?
No, just that news. Would Your Honour consider adding to Order 2 if the motions which are to be dealt with any adjournment application? That is to say, I should say, in fairness to Mr. Dowling, one can always apply for an adjournment in a sense, but Mr. Dowling is apparently specifically contemplating an adjournment application, and if that's to be something that's to be brought on, it would be inconvenient to the court and to the plaintiffs to first receive any evidence in support of such a motion on the Monday. But I just raised that as a matter for consideration.
Yes. Mr. Dowling, what do you say about that? If you're going to go off and understand you're going to apply for legal aid next week, presumably if you do wish to apply for an adjournment, you'll no doubt be able to put on an affidavit saying, here's the evidence that I've applied for legal aid and here's what they've told me.
Well, they don't give you an instant answer on it. You apply, and I can put on an affidavit saying I'm applied. That's not a problem.
Well, no doubt you can also ask them, it's a matter entirely for you, but you might also ask them how long they expect it might take. They may not give you an answer, but that would be a helpful piece of information for everyone to know if they were prepared to tell you how long they thought it might take for your application to be considered.
Well, there's a number of issues there, Your Honour, and I had the Crown Solicitor's Office harassing legal aid back in 2017, 2018 on a continual basis, trying to hurry them up. You can't hurry up a government department. That's just a fact of it. And Richard Keegan knows the Crown Solicitors because he was a witness in that matter, so he knows full well how it works. Now, if under the law, if someone applies and then they've got the opportunity to appeal it, it can take a substantial amount of time. But even so, once I apply, I'm not going to have a lawyer in a matter of days and be ready to go and briefed. If they had agreed to transfer it up here, I could represent myself. But I can't, and I really need someone on the ground down there, someone in court, so I'm going to apply for legal aid, which I'm entitled to do.
I think Mr. Dowling, what I will do is accede to the application that my order that I've just pronounced extends to your notifying any application for an adjournment and any evidence in support of that at the same time as you do the other motions.
Well, on Thursday.
On Thursday.
No, that's fine. I intended to do that anyhow, Your Honour.
Yes, all 2 of the orders that I've pronounced after the reference to notice of motions for recusal and transfer of the proceedings, the words "and any application for an adjournment," so that all of that will have to be notified with whatever evidence you wish to rely on by next Thursday, Mr. Dowling. But as I say, we will email you a copy of these orders fairly swiftly this afternoon, so you'll have them in front of you.
All right.
Now, I just will ask Mr. Smart this question, because we should deal with it while Mr. Dowling is on the phone. Mr. Dowling, do I take it then that you do not intend to come to Sydney for the hearing of these matters?
Your Honour, this matter is a scandal. I can't afford to go down there. That's why I moved. There's a whole heap of reasons I moved. And what do you say? Come to court where I get harassed by the court sheriff, where the police harass me after frivolous complaints by the court, and I can't afford to go down there anyhow.
Yes. Well, Mr. Smart, the question: does your side have anything to say about whether or not Mr. Dowling appears by telephone?
Yes, we have something to say.
Yes, which is what?
I'm instructed to pay his airfare.
Well, Mr. I don't know if you've heard that, Mr. Dowling, but Mr. Smark's instructions is that they will pay your airfare to come to Sydney.
Your Honour, I live 2.5 hours, 3 hours outside of Brisbane. And they want to pay my airfare. It costs me a lot more than just an airfare to get down there, and takes me a lot of time too. This isn't some minor trip. You have to remember, this has been going on since early 2017. It relates to apparently me, which is a lie, which is untrue, owning a website for a couple of months. And they've been trying to stitch me up ever since. They stitched me up in the Jane Doe matter, and Richard Keegan was a key witness in the Prothorary matter. And here they are offering which is only partial costs they're saying they'll pay.
I'm sorry to interrupt you, Mr. Dowling, but I'm saying this in your interest. My instructions are to pay Mr. Dowling's reasonable travel expenses.
Point 1. Point 2, I fully expect it to be transferred, Your Honour, to Queensland. Number 2, I'm fully expecting, and I'll put that in the notice of motion, as summary judgment.
Reasonable accommodation expenses, Your Honour.
All right, well, Mr. Dowling, there is an open offer from Mr. Smark's clients that they will pay your reasonable travel and accommodation expenses in connection with the hearings fixed for next Monday and Tuesday.
Your Honour, I'm happy to consent to that matter being, as well as the Capilano matter, being transferred to Brisbane. Now what they're saying is they want me to spend a couple of days coming down there for a frivolous and scandalous matter that shouldn't even be before the court. It's a joke. They say I owned a website for a couple of months, that's it, and they can't prove it because I didn't own the website. And why are they even follow through with this dribble?
Mr. Dowling, I think the appropriate course is for me, it's noted on the transcript that offer has been made. I would suggest, but I will not direct, that those instructing Mr. Smark will confirm that offer this afternoon in writing to your email, and I would respectfully urge you to engage with them in terms of taking advantage of that offer so that you can be here for the hearings, because if I may respectfully say so, it will assist you, quite apart from assisting the court. It will be much easier for you to do what you have to do to your best advantage in your interests if you are physically present.
Well, the other option is to transfer it to Brisbane, which I'm asking for.
I will hear that application if you wish to make it when on the Monday. That's what I've made directions about.
Yep.
And the other thing that I can, that is what I can do, that I can deal with the application on Monday Monday. That'll be the second application I deal with. If I do not accede to your application, to recuse myself. So,
Well, I expect both those applications to succeed, the first one to succeed anyhow, and it won't be any...
I beg your pardon, Mr. Daly?
Well, I expect both those applications to succeed. So the first one you will recuse yourself, then the next judge you'll hear will transfer the matter to Brisbane. So there's no need for me to come down there. They're not asking me to come. They're not offering to fly me down there for my benefit. They're offering to fly me down there because they know you've got the judges down there in the hip pocket. Because they know Chief Justice Tom Burthurst ordered the judges and the senior court staff to stitch me up, and it's in the police complaint, police statement by Chris Days. There's no disputing that.
Yes. Well, Mr. Darling, I do not know. Go through that. We'll just have to see what happens when I hear the recusal application on the Monday.
Yep.
And we'll have to play it by ear after that,
Yep.
Mr. Darling. But I would repeat what I said, that you really should engage with this offer that's been made to you, because it is to your advantage, quite apart from the assistance it will give the court, but it is to your advantage to advocate your position in your own interests if you are physically present. It is much harder to do that if you're on the telephone and to follow effectively what's going on in the courtroom.
I totally agree, Your Honour, and that's why I'm sure Your Honour's going to have it removed to Brisbane.
We'll see what happens then. I also will add to the orders I've just pronounced liberty to any party to restore on one day's notice by email to my associate. Is there anything else you would wish to raise at this stage, Mr. Darling?
No, Your Honour.